Well, welcome everyone to our second panel here at Washington Arbitration Week, Day 4. It's a pleasure to welcome everyone here to Crowell & Moring. My name is Ian Laird. I'm a partner here at Crowell and co-chair of our International Dispute Resolution Group. I also wear the hat of one of the co-chairs of Washington Arbitration Week, along with Dr. Jose Antonio Rivas of X-Strategy. I don't take the opportunity enough to mention Jose Antonio. This event this week was something that many of us in the Washington arbitration community talked about for years as something that we should put together. You know, one of those things that you just kind of talk about and no one ever grabs the bull by the horns. And Jose Antonio and I were certainly part of that discussion. And when COVID came along, we really thought that was a low entry opportunity to do a virtual conference. And we started off fairly ambitiously in that first year. And people were desperate for connection and content and to interact. And in 2020, it was really a marvelous success. And that gave us a great deal of momentum as we came out of COVID and into in-person again. The enthusiasm and take-up and the general goodwill and energy to continuing to do the conference just continued to grow and grow. And this year, I think we've had really fantastic support from our sponsors, from our law firm sponsors, from our experts, from our institutions, and thank you all as well. But just back to Dr. Rivas and X-Strategy, which is his firm, which plays a major role in organizing, along with Maria Matamala, and the whole team at X-Strategy. I think we can't say enough to them for their excellent work and herding all these arbitration cats. So thank you to them. Our second panel today is titled, Are Dissenting Opinions in Arbitration Useful? How may dissenters contribute to move the law forward in international investment arbitration? Obviously, that title has a few premises in it, and we are going to unpack quite a bit of that. We have an excellent panel here today, a real rogues gallery of folks in the DC arbitration community. I'm sure they appreciate that description. But this is a debate that, of course, is one that continues on in the arbitration community. And some have very strong opinions, some sit on the fence, as well as being, for or against. And I thought, before we get into our discussion, and we're going to organize it in a bit of a format of a debate. I've assigned positions to our 4 panelists, and they've agreed to play along. I think at the end of the day, you'll probably hear what their real views are, but for the sake of making this interesting and entertaining, I think that they were game, and so we'll see how that works out. But to start the panel, I wanted to just get maybe a show of hands about folks' initial sense of where they stand on this issue. So those who think dissents are a good idea and are generally supportive of that concept, can you put up your hands? So that's just using my prerogative as moderator, that's kind of a 40 to 50%. And I would, well, let's get to that, Todd. And so I guess the counterpoint is just to see your hands, those who take the opposite position. Would that be the rest of the group here? Who don't think much of dissents. Okay. So we'll see if this group changes that view as we go along. There are of course, a lot of moving pieces in this debate. And if we look back over the last 10, 15 years, there's been some interesting academic discussions, certainly a lot of articles on this topic. It's just one of those topics which doesn't seem to be able to get to a final resolution because it really does go to some fundamental issues, cultural issues, legal background issues, the predisposition of the individual themselves, all sorts of factors, which I do want to get into. But before that, let me introduce our panel. So my name is Ian Laird. I am your moderator. I've told you a bit about myself already. At the end of our table, we have Professor Charles Katubi Jr. and Chuck, as he is known to us, is based here in Washington, D.C. He's of counsel at Three Crowns, and his practice as counsel is focused on international commercial and treaty arbitration, transnational litigation, and public international law. He was previously at another international law firm here in DC. Chuck is also a full-time professor of practice at the University of Pittsburgh Law School of Law, an honorary professor at Durham Law School, and visiting professor of law at the Kiev School of Economics. And it goes without saying he teaches courses in international arbitration, public international law, and international human rights. So this is, of course, I think one of the issues that Chuck is always happy to grapple with. And next to Chuck, on his right, is Keisha Jane. Isha is a special legal consultant based here in Washington, D.C. at Three Crowns also. So we have a Three Crowns team here. She has experience in international commercial and investor arbitrations across a range of industries, including energy, construction, and intellectual property. She's a Harvard Law School LLM grad, where she received the Roger Fisher and Frankie Sander Prize for Best Student Paper on topics related to dispute resolution. She also has an LLB from the National Law School of India. So it's great to have Isha here on our panel. We also have next to Isha, Mallory Silverman. Mallory is described in Who's Who as, and I quote, this is a great quote, one of the world's most experienced young practitioners of investment arbitration, unquote. So I think that just absolutely, she's the person for this panel. And she's acted as counsel and very interestingly represented investors and 17 different states in over 50 treaty cases. So very experienced. She recently left private practice. She was at Arnold & Porter as a partner here. And she advises me that you'll be able to hire her in the new year as an outside consultant coach for your team. So I definitely recommend looking to Mallory if you need to bolster your bench. And then finally next to me is Dr. Todd J. Weiler, not to be confused with a congressman who's apparently in Idaho or Montana. I don't know. Whenever I pull up your name, some state senator. Yeah. So this is the arbitrator, Todd Weiler, not the Republican state senator.
Hillary Clinton.
So Todd has been counsel, expert, academic, and now full-time arbitrator for well over 20 years. I think almost 25 years 26. And 26. Okay. So you got to count those. So he's well recognized, of course, in GAR and Who's Who Legal. He has been, I would say, a pioneer in many ways in the ISDS field, working with me actually on some of the earliest NAFTA cases. He's a founder of Oxford University Press's website, investmentclaims.com, which competitor of our Jus Mundi, our previous panel's moderators.
So are you, by the way.
Yeah, I am as well. And as well, one of the co-founders of the Society of International Economic Law. I didn't do that. No, Todd. Yeah. Todd's whispering in my ears for you online if you hear me reacting. So Todd is a longtime contributor and writer, having edited, authored, co-authored, co-edited dozens of books and articles, and it's always great to have Todd on one of these panels dealing with some of these navel-gazing issues in arbitration. Todd.
And I'm not young anymore.
Todd is a young man.
But I will take it.
He started arbitration when he was 5. He is only 30 now. No, just kidding. It's possible. It's possible. So let's get to our issue. When we talk about dissents in international arbitration, one question comes to mind. You ask the question, so where does this stand legally? Is this permitted even? And I think if you come from a European perspective, a civil law perspective, you might say, yeah, this isn't something that I know about. Our courts generally don't encourage this. There's a priority placed on collegiality and consensus, and many rules actually don't allow for this. If you look to the Hague Convention on the Pacific Settlement of International Disputes, if you look to the European Court of Justice, you don't see dissents. But if you're, I guess, a common law lawyer, dissents are heartily recognized and encouraged. And, when ICSID was being negotiated, and this goes, of course, back to the 1965, there's a specific reference to the allowance for dissents and concurring decisions. And as well, we see them, of course, in the ICJ context, in the PCIJ, and they were common in the Iran-US Claims Tribunal. So in the ISDS world of investor state dispute settlement, this is something that has been a fairly common practice. Now, going to kind of the principled distinction between arbitration and litigation, you can start digging down and asking yourselves a few questions. Arbitration has a number of values which are quite distinct from litigation. Efficiency is preeminent. We had a whole panel last night at ICSID talking about efficiency as an important element of ICSID arbitration. Awards are final and binding, generally not appealable, subject to limited enforcement challenge. Consent and the party autonomy play very important and key issues. There's no stare decisis or precedent. So a very different beast than, say, litigation, which of course is not final and binding. There's a continuous ability to appeal and to challenge. The objective in litigation is much more on creating ultimate certainty. It's not clearly about efficiency. And the idea of consent of the parties, that kind of party autonomy value, is certainly not at all part of the litigation world. So when we look at the idea of dissents, one could argue, and we'll see what our panelists have to say about this, that arbitration is much more suited, being more of a civil law style dispute resolution process, that it's much more suited to a collegial consensus building exercise. And we'll see what our panelists say about that. Now, just to give you a little bit of background on the academic kind of discussion on this, we saw about 10 years ago a interesting interaction between some very senior arbitrators in the form of Albert Jan Vandenberg and Charles Brouwer, both of them having very distinct and contrary and asserted and certain views as to the value of dissents. And to put them in their camps, Vandenberg has a hearty dislike of dissents coming from his civil law tradition, and Judge Brouwer believes that dissents play an essential role in the adjudication process in investor state arbitration. So very diametrically opposed views. So I'm going to ask our panel to channel a bit of that energy and enthusiasm, if they're so minded, for dissents on the side arguing that dissents are a good thing. I think we have Mallory and Todd. And at the end of the table, we have the Three Crowns team of Chuck and Isha arguing against dissents. Now, I have to say as a caveat that this, nothing, well, I don't think you can take anything that anyone's going to say as their personal view necessarily in the interests of the discussion, unless they actually say, no, this is my real view, but that's up to them. So this is for the purpose of good academic fun, and we'll just dive right in then. So Vandenberg, in his article, arguing in favor of dissents, said it will not having dissents leads to 4 benefits. It will lead to a better award. So going to quality, the majority will act more responsibly. The idea that dissents create an unfavorable kind of interaction amongst the parties. His third point is it will bolster party confidence in the process, not having dissents. And fourthly, it will contribute to the development of the law by having a consensual, fully agreed three-member decisions, that it's better for the development of the law. So this sets out a few of the kind of touch points for this discussion. So let me start with party autonomy and consent. The fact that the parties choose their arbitrators is clearly one of those benefits of international arbitration that we all talk about and we tout. It's very different than litigation. There's an element of forum shopping there, whether that you consider that good or bad, it's considered a benefit. But this also raises the issue, and this is a related issue that certainly Brower identified in his piece about the kind of implicit relationship between the parties that appointed the wing arbitrators and the fact that when you look at the dissents, when they've occurred, and it doesn't happen frequently, I think maybe a quarter of the time, depending on your stats, the arbitrator doing the dissent is almost always, well, I think it's always the person appointed by the losing party. And that, in Vandenberg's view, was too close a connection, and that called into mind that there must be something in his estimation going wrong there. And of course, Jan Paulsen weighed into that debate somewhat with his paper, and he was talking about the Lowen decision, a famous NAFTA decision, that went kind of Bowery in his argument for getting rid of the party appointment. And that kind of flows into this party autonomy issue. So let me go to then setting that issue forward, go to our folks who are in favor. So Chuck and Isha. So Chuck, maybe I'll start with you right at the end. So what do you say about that? Are you against? Oh, sorry, you're against. So actually, let's start off though. You're against. Yeah, I got to get that right. Yeah, and bring the microphone close, because
yeah. And you're right. This is we're going to assign these roles, but I will say I'm not going to say something that is completely against how I believe here. I first of all, I disagree with the categorizing the civil law common law divide. I think really it's arbitration versus litigation divide, right? What are you paying for? This is sort of my view here. What are you paying for? You know, litigation, you're paying for nothing. Right? You're not paying for the judges, you're not paying for the court, you're not paying for the clerk's time. It's relatively cheap, right? But the implicit cost there is you're subjecting yourself to being part of the lawmaking process, right? Now, I've done a lot of litigation as well as arbitration in my time, and I can tell you that no client loves the fact that their case is going to make law. right? It's going to go to the circuit and it's going to go to the whole way to the Supreme Court. It's like being told that you have a really interesting brain tumor, right? Everyone wants to come and look at it, but no one wants to have it, right? And that's the cost of litigation. So why do you get out of litigation? You go to arbitration, where you're paying for 3 individuals, party autonomy, to appoint someone to decide your case. I'm sort of against the notion that one of the party's appointees, as it usually is, decides that part of party autonomy is a right to get a dissenting decision, right? Is the right to have your views vetted publicly as part of the tribunal's award. I think that we're not in arbitration necessarily to develop the law in this way. That's not what we're getting paid for. We're getting paid to settle the dispute. And we can talk more about this later because this treads into what we're going to talk about with precedent. But if an arbitrator feels that their decision is necessary to be stated in order to move the law in a particular direction, go write a law review article. International law puts judicial decisions and scholarship on the same level. Don't do it on the party's dime. Work with the tribunal to get to a consensus decision, and I'll leave it there and see if Isha has anything to add there.
Yeah, thank you, Chuck. I agree with all of that. And I'll just say that in the decades since Vandenberg published his article, a number of authors have attempted to respond to it, and none of them have provided any good reason why almost 100% of dissenting opinions in investment arbitration are authored by the arbitrator who is appointed by the losing party. Judge Brower authored another article this year suggesting that these dissents are warranted because they provide some sort of comfort to the losing party and might help them accept the outcome of the arbitration. And while that might be some sort of beneficial effect of these dissents, it certainly can't form the basis for issuing them, because the only principled basis for issuing a dissent is the existence of a genuine disagreement on material points of law or fact. And so it's just difficult to believe that all of these dissents have been issued on this principled basis, but still somehow all happen to favor the losing party. I'll stop there.
So to our affirmative panelists here, any reaction to that, but specifically on the party autonomy point and Vandenberg's point about, the losing appointed arbitrator always seems to be the dissenter as somehow sullying the whole idea of dissents.
It's a false dichotomy. I mean, how else could you have a dissent or a separate opinion? If you have a majority that does this, then anything that is not this must be that. So it doesn't make any sense to cast an aspersion upon the that because it's not the this. It's illogical. I mean, obviously that has to happen. So it's sort of like complaining about the fact that why is it always at night when things get dark? Because they do. I think that the focus here should be on what the arbitrator's role is, but specifically as to the statements I just heard. The problem with the Vandenberg approach, though, is that he rejects the principled basis for a decision being a disagreement, a good faith disagreement. He rejects that as legitimate. He says that's not a good reason to dissent. So what is?
So I think that I agree with Chuck on some points and Isha as well. I don't think I'm sold on the idea that arbitrators can just grandstand, that they can make the parties foot the bill for everything that in theory might contribute to the development of the law. If they want to, as Chuck said, they can write a book, write an article. They don't need to write a dissenting opinion just for this. But at the same time, it's still appropriate in some circumstances to have a dissent, and dissents can still be very useful. So I think one of the reasons why in the past 10 years, maybe no one has come up with a response is because this hasn't really been a contested issue. We just had a very lengthy process for the amendment of the ICSID arbitration rules. And in the thousands of pages of working papers and in the hundreds of pages of compilations of comments from various stakeholders, you don't see anyone contesting the notion that in principle, you can have a dissent. That surprise anyone? Dissents aren't in question. They are not something outlandish. Separate opinions are permitted, as Ian said, in various fora. They're referenced in the ICJ statute. They are explicitly authorized by the ICSID convention. And we don't see people dissenting on the notion that a dissent can be useful or is permitted, perhaps because there's a way to opt out. If you don't want to have a dissenting opinion, you don't have to have one. You can agree with the other party to appoint a sole arbitrator. But if you have a 3-member tribunal, I think it's really difficult to say that there can't ever be any dissent whatsoever in any circumstances. Just on a personal level for an arbitrator, I think it would be really difficult if you know that you essentially have to sign an award. In theory, you can abstain from signing the award, but what are you really going to do? Abstain from signing the award and not provide any explanation as to why you're abstaining from signing? To me, that would seem to throw the award into more doubt than just having someone explain why they disagree with the majority. So I think dissents can be useful. There obviously is some tension between what the parties want in a case and what the spectators in the community might want for the law to be moved forward. But dissents are here. They haven't been challenged over the past 10 years. And if there are statistics that show that arbitrators are, I guess, issuing opinions in favor of the party that appointed them, that may not be something causative. It may just be a correlation. It could be that parties are doing a very good job of selecting arbitrators that agree with their views. And in the end, they're just not able to persuade the other arbitrators. It's not necessarily some manifestation of bad faith or something improper. It could be people doing a good job.
I suppose it is possible. It would be possible to have an arbitration clause drafted that says that the arbitrators must come to a consensus. And I mean, that might, of course, lead to a stalemate, but in theory, you could basically say no dissents by saying they must come to a consensus.
Well, I mean, essentially, that's the civil model, that they don't permit dissent. So that is required. And there's
Or you require someone to sign something they don't believe in, which also has problems.
Well, and that goes to the whole question of deliberations, of course, and what goes on behind the scenes and how the 3 arbitrator panel interacts, or, you know, for the instance in the European Court, how they interact and how they get to that decision. That's for another discussion as to how that works. But let me go to the point that Chuck raised just to get your response from our pro-dissent folks. I mean, is this a cultural issue, or is this really goes to the argument that I kind of served up initially? Is this a litigation versus arbitration kind of divide? How do you view that issue?
I mean, as someone from a common law jurisdiction, I wouldn't say that on the whole, we're not collegial, or that I am not collegial because I'm from a common law jurisdiction and might have an individual opinion. But it is true that your background in legal training probably will have something to do with what you think about on this issue.
Can I respond quickly to what was just said? And one thing I think, if I can step out of my role a little bit and say what I actually think, is that at no point do I think it should be disallowed, because I think that the threat of a dissent is a really good one. The title here is, "Are dissenting opinions useful?" I think I actually believe that there should be some, social pressure. Social pressure is probably the best way to put it, against dissents. Like we really should, as a regime, try to create a system where dissents are the rarity, where you only dissent if you absolutely have to, cannot put your name to something and need to say why. They're there. They're going to remain there. And I think there's a good that they remain there, because if they're not there, I think if they're not there, you do run the risk, which is equally problematic in arbitration, I'm seeing more and more, are split the baby decisions, right? I think it would actually be better for justice if the two arbitrators who agree on a certain robust decision feel like they can issue that robust decision in the face of a dissent, as opposed to they both get together and issue some award, both sides get together, issue some award that says you win, but you get no money. And that's the only way that we could get together and get some sort of consensus, right? I think that's actually worse. So I think dissents need to be there to push that pressure on the arbitration tribunal. However, I do think that we need to really be thinking as arbitrators that this is the nuclear option. I think that's my view.
Yeah, just to build on that, I completely agree, and I don't think it's this binary between a collegial approach and a purely individualistic approach on the part of the arbitrators. There's certainly no strict expectation of a consensus award, but I think there is an expectation that in the deliberation process, the arbitrators from whatever culture they come from will engage in a free and open exchange of views and even be open to changing their minds. And in an ideal world, that good faith process would result in consensual results more often than not. So I think the answer lies somewhere in between this collegial and individualistic divide.
Yeah, I don't even understand the idea that that individualism actually has anything to do with it. I think it's the professional responsibility of the arbitrator to in good faith, come to a legitimate, as far as they're concerned, a legitimate and a reasoned basis for their finding. So if that's the objective of the arbitrator and the two other arbitrators share that and they all are operating in good faith, collegiality will necessarily exist. It's only individuality in the sense that they're not all one human. I mean, because there are three different humans, they will have some individual characteristics, but to say that people who dissent are more individualistic is not, I think, not only unsupported, it's also beside the point. But one of the things Chuck said, which I wholly agree with, would be with respect to only having to dissent when you really need to. So the first time and the only time I had to write a dissent was in 2005-06. And in that case, I really had no other choice. I disagreed with the finding, and I had studied a lot of the law and written about it, and I thought they were wrong, the majority. So I contacted Martin Hunter, who had recently been an arbitrator in a couple of my cases, and he become sort of like a mentor. And he basically said the same thing that I found was attributed to Redfern, unsurprisingly, in, I think, one of the Vandenberg articles, which is that if you're going to dissent, it has to be truly necessary, and it has to be polite, and it has to be short. It has to be concise, right to the point. And so I followed that. The only question I guess I would have in retrospect is, I felt at the time that there was very much a cultural norm or more against, well, I'm sorry, in favor of consensus against going off. Maybe that's because it was like over 20 years ago, or maybe it's just because we need to remember that there's enough of us, there's a sufficient mass of us at the international arbitration community level that we have our own mores. And one of the mores, which is basically a mélange of the civil and the Anglo-American / Canadian approach. This is where you get this pressure that you generally do want to reach consensus if at all possible.
That's sort of built into the rules too. You know, you have the ICSID convention saying what the tribunal needs to do in respect of the award. The tribunal needs to draft its reasons, and built into that is the notion of this consensus. 3 people coming together to jointly draft an award. But sometimes there are going to be disagreements when three different people come together and look at issues of law and issues of fact. And I think that having the possibility of dissents creates this safe valve. That doesn't mean that in every single situation, a particular dissent was something that I necessarily would have done or would have agreed with, but it's still, I think, on the basic level, a good thing for the system to have.
Before I forget, another idea just came to mind. Is this on? Yeah. Thomas Volda, a friend of many who are a little bit older here. I had appointed him as an arbitrator in a Mexican case, International Thunderbird Gaming. And I kind of had a thing going with him afterwards because I went and represented the claimant. I'd always say, well, your dissent. And he'd correct me and say, no, my separate opinion. He would refuse to call it a dissent. He said, no, it's my separate opinion. So I guess that we have to kind of address that aspect of it too, because it's really not just dissent, or maybe it is.
I think in that case, Thomas was very much disagreeing with the majority, but yes, he was a very well-mannered and proper person, and he just couldn't swallow the word dissent, which goes to the more of his character, but no doubt he was contrary. Let me go to another related issue, and you know, when we talk about the values of arbitration, efficiency is obviously something we look to final and binding awards. You know, as Chuck was saying, you know, this is service industry. We're all servicing the process. And I'll give this back to the anti-dissenter viewpoint here for your view. I mean, really, I think I'm just laying it in here. Isn't dissenting complicating the process? Doesn't this lead to extra costs, time, and ultimately serves up the basis for a challenge, which again goes to cost and inefficiency. What do you guys say, Chuck and Isha?
Yeah, and to me, I think dissents can be inefficient. They can be really inefficient. It's not because necessarily I'm worried about using my party's resources to pay for a dissenting opinion. I mean, although that's part of it. We're splitting the cost of this process. You know, and a dissent could lengthen the length of time to get an award, but if you have a strong chair, the chair should be able to say, hey, we're not going to just give you another year to write a law review article. We're going to get an award out, right? So it requires a strong chair to make sure that's not the case. The worry for me with dissents is that your appointed arbitrator becomes your lead counsel in an annulment case or a set-aside case or a case against recognition and enforcement. So that person sort of starts, if we start encouraging dissents by the party-appointed arbitrators, the ones who want to get that job are going to see themselves as laying the groundwork for an annulment case or a set-aside case. And they're going to put forward the case that is going to be run through into that process. If you look at cases where there was a set-aside or an annulment, where there was a dissent, that dissent is heavily cited, heavily quoted. And are we getting into a decision if dissents become more and more commonplace? Are we getting into a system? Are we building a regime where annulments and set-aside just become par for the course, which unfortunately they kind of are, right? And I think as a regime, we need to reckon with whether that's what we want or what we don't want.
Right. So I don't think dissents are illegitimate just because they may add to time and costs and just because they may undermine the authority of the award. Because there may well be awards that do lack reasons or do suffer from a serious procedural irregularity, in which case there should be a dissent that undermines the authority of that award. But I see the problem as being that dissents themselves have come to lack authority because they are always authored by the losing party's appointee. And so while dissents can play this important role in policing irregular awards, their efficacy is diluted by their ubiquity. And so there's reason to be more restrained in issuing dissents and for reserving them only where there is good reason to depart from the majority.
So pro dissenters, what do you think about the efficiency point? Is there an answer to that?
Okay. So a couple of things. The first one would be as regards the reputational value of any decision or its persuasiveness, including a dissent. I think that's got a lot to do with who the person was who wrote it, and if they have a certain gravitas or a reputation for being, being a team player, but someone who has good ideas, then maybe their ideas the dissent will be successful, at least in terms of its quality and its potential for being quoted in other cases. Something Chuck said, which was interesting, is I certainly agree, of course, that that annulment is now just assumed to happen. I think that's mostly, though, because of the kitchen sink approach to litigation that I originally saw in trade law, but I think also applied pretty soon into investor state law at a young age. And that's especially true on the part of the respondent, because as a general rule, the respondent's counsel aren't actually on a budget. They may be on a budget to some degree in some way, but ultimately, if political necessities require more, they could get more. And besides, it's not their fees directly. But the funny thing is, though, that if there was the kind of error that would cause an annulment to take place, then by dint of logic, it was one that had to be brought up by the dissenting arbitrator, right? Like if there was a fundamental failure in due process, or if it's clear that they went far beyond their remit jurisdictionally, well, it would be incumbent upon the other arbitrator, if they couldn't convince their colleagues at the time, that they would have to set that out. So I wouldn't say that that's setting the course. That's not playing counsel for the next case. That's just saying what happened. So, I mean, ultimately, though, all of this goes back to good faith and professionalism. The self-aggrandizing arbitrator who writes too much, who takes the party's money to write a law review article, much less even publish a law review article based on it, or the person who is just grandstanding, or the person who doesn't understand that all three arbitrators are supposed to be independent. They're the anomalies. The actual standard that we all presume to live by, and I think we all do, is independence, impartiality, acting in good faith and in a professional manner. And if that's the assumption, I think a lot of these critiques go away.
One other thing that might help is if someone feels so strongly that they need to dissent, they need to say something rather than just sign an award that they don't believe in. In theory, they could decide not to charge for that time. It doesn't solve the entire problem, because then the majority presumably still needs to deal with the dissent in the body of the award. But that's one way to respond to the efficiency and cost concern.
If you can't keep it short.
Right. But then it encourages people to be short and dissent when they need to, and not write a law review article.
I assume, though, you mean in that context, you're referring to basically a moire rather than an actual rule.
Yes.
Okay.
Can I add on to something that Todd said? And this is the part where I eventually agree with Todd. See, collegiality, right? We're not all just fighting up here. I do think that there's a dichotomy too on what the dissent is about. And one thing you said about due process and procedure, I think that is something that the party appointed arbitrators are absolutely there to police, to make sure that each side had their due process right to be heard. And if something like that happened, then that's an absolute obligation to dissent, rather on the scope of the FET obligation or something like that could just be better put into a law review article. But the last thing that I think is important, this goes slightly beyond what we're talking about, but I think it's mixed up in this, is good faith and collegiality. I've been doing arbitration for about 20 years. And over those 20 years, I've seen a steep decline in just professionalism amongst counsel. right? I think there was a point when I first started in this practice where it was a bit more of a gentleman's game, as opposed to litigation. Now it is much more brass knuckled as a matter of practice. And I think that bleeds over into some of the more, proclivity to dissent among arbitrators, because that's what they feel that their party wants. And I think that's a bigger problem that the institution needs to grapple with.
So before I go on to my next issue, I still want to give our four dissents panelists a chance, but on the efficiency issue, I think your co-panelists made a pretty good case on that. What do you say, even just a short response, what do you say about the efficiency and the opening to challenge part?
I think it's been covered. There are circumstances where it really does make sense to dissent because there have been serious irregularities in the issuance or the creation of the award. And then it's incumbent on the dissenting arbitrator to bring these to the party's attention. And that will come to light during the course of the set aside or annulment proceeding. But I think it's a very real concern that dissenting opinions increase the time that it takes to issue an award. They increase the costs for the parties before you conclude the first part of the case, and not even including the costs of a set aside or annulment proceeding. So to me, the one thing that I could think of that might be an answer is this idea of keeping it short, have an arbitrator who feels strongly enough to issue the dissent say, I feel so strongly that I need to do this, that I'm not going to charge you for that time. There are still some costs because, as I mentioned, the majority needs to deal with the dissent, but that might assuage some of the concerns.
So again, it might be just it's a sample of one to begin with, but also it's back in time. But back in 2005, after the case was heard in which I dissented, maybe it was my youth even, I felt quite, I don't know, I felt it quite urgent to put my dissent in quickly. And the head chairman, he actually set times for it. He said, okay, if you have a dissent, you've got 2 weeks. And it's going to be after we've already done our first draft, and we will have a final draft after we see your dissent. Boom, boom, boom. And maybe it's because of my youth that I didn't go, hey, wait a second, but I didn't. I simply complied with that schedule and got my dissent in. So, I mean, I think this can be handled simply by the chairperson. I mean, I guess the only problem that might happen is egos. But I think another really admirable trait about an arbitrator or a lawyer is humility, and therefore being willing to subliminate your ego sometimes when an idea is strong, but you realize that your primary fidelity is to doing a good service for the people who appointed you.
So thanks for mentioning your case. And just to give everyone a little background, I think it's called Bershader.
With them actually.
Was it two? Two
brothers.
Two brothers. The plural Bershaders. And MFN was the issue. So most favored nation. And 20 years ago, and granted there's still some contention, but it was a well-discussed issue. Certainly a lot of contrary decisions. And, I could argue that your contribution was part of the kind of zeitgeist of the time about where one could come down on the issue quite legitimately based on case law, principle, et cetera. So I guess it goes to the question, and maybe you can talk to this, Todd, since you're the expert, but did you feel you were contributing to the development of the law? And, this is all in the context that, there is no precedent in investor-state arbitration, but there is this concept that, awards do, they're part of the, arguably and part of the interpretation of treaties process, part of the ICJ statute's view of what international law is. I mean, there is a role for certainly decisions, but, where do dissents play into that?
I just think I was right. And I had I've been.
Was that the closing sentence?
Yeah, no, but I've been working on my a dissertation back then where non-discrimination and what's the word, equality of treatment were big components. And I had done a lot of research and uncovered this 1948 article by Schwarzenberger that was wonderful, that it basically said that and the idea really sticks. It said that the purpose of the MFN clause is to put the services of the very best negotiators in the world in your favor. Meaning that you negotiate your deal, you put the MFN clause in. Now, when somebody who's better, more talented, has better, better power relationship, can get a better deal, you get the upgrade, you get the uplift. So, I mean, that's MFN in a nutshell. And I thought that it didn't make much sense in that particular case to basically come up with a default that suggested, unless it's explicit that it says that, it's not bad. Because I thought, well, no, it should be the other way around, unless it's explicit that MFN shouldn't mean what MFN means then. But anyway, the funny thing is, it's actually you and me in our early cases who I think developed an ethos of, as counsel, trying to move the law and trying to build the law. As an arbitrator, even then, I really wasn't interested in building law because I don't think there's precedent in international law. I think it's just about persuasiveness. So because I don't fundamentally accept the idea that there should be or can be or ought to be precedent in this field, then it's not really about developing the law, because there is no the law to begin with. But that's probably a minority position.
I still have a hard time with this idea that it is for the arbitrators to look beyond the case and think about, I don't know, investment arbitration as a whole or what the law should be in the future. It's the party's case and they want for it to be decided. As Chuck said, they don't really care what happens beyond the four corners of that case. But at the same time, I have started to see a lot of awards that say, well, we think that we really need to adhere to the consistent line of jurisprudence that has developed on X or Y issue. And sometimes the jurisprudence that has developed on that issue just doesn't seem right. So I think there is a concern that if people are just sort of rubber stamping what someone has done previously, we're going to end up at a point where the principles that we have in the system no longer make sense. And I can see in that context the benefit of having someone write a dissenting opinion and say, this was never logical in the first place, and I'm not just going to rubber stamp it here. Again, you have that question of whether you're playing to the spectators in the system or the parties in your case. I don't know how I feel about that, but I can see the value in someone stopping and saying, I don't agree with this.
One more quick point. I'm reminded of a long time ago when I was a clerk to a federal court judge in Canada, and he generally let me do all his reserves and give a first cut. And he agreed with me on every single case but one. And the one he disagreed with me on, it was like a First Nations case involving railways or something. And he looked at it and he said, you're confused. This is not the Court of Appeal. I'm a trial judge. I apply the law to the facts. If you want to change the law, that's what appeal does. And I would argue that probably the very same admonition could be applied to arbitrators.
Well, hearing from our pro camp on this development of international law, Vandenberg absolutely he did an analysis of the decisions and he came to the conclusion there was no benefit to the development of law in a dissent. But what do you guys have to say about that issue?
Yes, so I think it goes back to the distinction between courts and arbitration, because courts serve a public purpose. They are funded as such. So they operate beyond the resolution of a single dispute. They create binding precedent in a lot of jurisdictions. And so there's good reason for courts to issue non-binding opinions that will develop the law, whether it's a dissenting opinion or a separate opinion or a concurring opinion or an advisory opinion. But arbitral tribunals, by contrast, are constituted for a private purpose and are privately funded by the parties that constitute them. And so their focus should be on efficiently and finally resolving that dispute. And none of this is to say that arbitral awards do not contribute to the development of international law, just that any such contribution is not the primary role of a tribunal. It might just be an incidental effect of their awards.
Yeah. Well, you know, our role is here to be entertaining and provocative, right? So I'm going to say something provocative, but it happens to be what I believe. If you read most investor state arbitration awards, they're pretty lean on jurisprudence. It's a pretty vanilla explication of where the law is, right? You don't glean too much out of it. And then the disagreement in the outcome of the case is on applying the facts, how the facts apply to it. So my view is if you're trying to nudge the law and want to write for the ages, as I think it was a Chief Justice John Roberts used in a case recently, writing for the ages, put it in a book or in a law review article, not in a dissent, right? It'll get read more probably, especially if it's not, you know, behind the cloak of confidentiality. It'll get read more, and you can actually write for the ages untethered to the facts of the case, because that's what you're trying to do here is deal with the facts of the case. And my view on the law here is also a bit societal. I mean, we live in a very narcissistic time, right? Where we all have opinions. We can, with the press of a button, I can scream my opinion from a megaphone, right? Rather than trying to get together and meet consensus and coherence and with a side that might have a principled disagreement with me. I actually think that the law would develop better if arbitrators of different viewpoints would come together and try to put together a coherent thought that they both agreed with. You might have a more balanced evolution of the law rather than a scattershot of here's my opinion, here's my opinion, here's my opinion, here's my opinion that doesn't really lead anywhere. And that's really, you know, putting my academic hat on, that's the peer review process, right? If you're writing an article, you get it peer reviewed by people who disagree with you, and they tell you why they disagree with you, and then you adjust your opinion to that disagreement. That's sort of the process of writing an award without a dissent. So, you know, I think when you talk about the development of the law, you know, putting myself out there with a dissenting opinion, I don't know how much that really does.
Wait. You're saying that your peer reviewers don't agree with you wholeheartedly? Like mine?
They do.
Oh, it's a shame.
It's because you're always right, Todd.
Yes, yeah.
That's
Now we have a few minutes left, and you know, we've been circling around issues related to culture and legal background and those kinds of things. Let me ask the question about dissents in investor state arbitration as distinct, say, from the commercial context or even litigation. Is there kind of a more of an imperative, we'll say, in investor state arbitration because that states are involved, a state is involved, international law is involved, that there be you know, an extra effort to arrive at an award that will be viewed as a strong award and that is, you know, definitive and, you know, not using all those words, but, you know, that there's an agreement between the three arbitrators so that there can be kind of a higher level of confidence. Is there something about the ISDS milieu, which is different from litigation or commercial arbitration in that world because of the stakes that make it more important? And maybe I could start with Chuck and Isha on this, because the premise here is that this is something different. Is it different? Is it something that should be considered?
My view is that it is not something different because that's the regime we chose. I mean, investor state investor-state arbitration, historical evolution of the regime was trying to lift these politicized disputes out of courts. And we lifted them out of courts. We had to paint against an arbitral canvas, right? So the arbitration model is what we chose. We didn't want judges who are arms of the state deciding these cases, right? We wanted individuals who were chosen by the parties who didn't have a reliance on the state for their salary or their safety, et cetera, et cetera. So I think that trying to start viewing ISDS as, you know, more like a court because you're dealing with public issues and the development of the law is really wrong-headed, because we're going backwards. We're going backwards quickly from what we tried to get away from. And I think what I said earlier really reigns even more true, that you need to find consensus here in these awards, because in investor-state arbitration, unlike commercial arbitration, you have two groups of arbitrators out there, right? There are the people who you know are going to be claimant and investor friendly, you know are going to be state friendly, right? And so you have an even greater polarization. So if we have more, if every case there's a dissent, you really are going to get a scattershot regime rather than coming together and finding consensus, which in the realm of public policy should be really where we're trying to do that and get a balanced view of the law. So I don't think it's different. And I think there's a good reason why it's not different, and it's historical. And I think by equating it more to like litigation, we're regressing. That's just my view.
I generally agree. And I think if anything, the political undertones of ISDS should be a reason to discourage dissents even more than in commercial arbitration, because there exists a risk that states, for example, could pressure or even coerce their party-appointed arbitrators to rule in their favor. And even if no such express pressure exists, surely the trend of issuing dissenting opinions in favor of the losing party creates an implicit expectation that an arbitrator will conform with this practice. And so by discouraging dissents or by making them less ordinary, you remove some of that pressure that may exist on a party-appointed arbitrator to dissent in favor of the party who appointed him or her. And you also reduce the perception that these political factors are influencing the issuance of a dissent, which I think is harmful to the legitimacy of the ISDS system as a whole.
So let me ask our pro dissent crowd, is ISDS something different?
No, and no, it shouldn't be. It shouldn't be, because there's a potential to weaken the fundamental and also special nature of this regime based on all these different treaties, that a state is willing to subject itself to the decision-making of impartial, independent, international arbitrators, and that they will generally, in theory, abide by that result. That process, that idea, the independence, impartiality, and international quality of it is arguably the most essential part of it, because without that, you don't really have decision making. Instead, you have some sort of, it's really meant for the diplomats to take care of rather than the lawyers. So if you bring in this idea that there needs to be some more deference, and that deference in some way should change the way the decision maker or the arbitrator would do their job, you're spoiling the whole point of the mechanism, which is to leave it impartial, independent, and international. You don't want to talk about deference, which of course is why, as we know from that, can't think of the case off the top of my head, but where was one of the case, it was a Latin maxim that arguably was extinguished in the Vienna Convention, but nonetheless, states occasionally used to try to use. Do you recall what it is? I can't think of it off the top of my head. It's where the state says, you owe me deference in the way you could decide this. I just can't think of the name. There's been enough arbitrators who in our board said, no, that's not true, that it's not a thing anymore. But it was an argument that was made a fair bit. So no, deference on that basis would be really bad. perhaps the final reference to the past for me. The pressure that I felt to not dissent, but if I had to dissent to follow the Hunter Redford model, was that I knew that most of these folks came from a commercial background, and that it was well known that in the commercial arbitration field, consensus was the norm and was very much preferred. So as long as the primary feeds into our arbitrator class or group or community have a commercial law background, I would assume that that culture is going to remain the same. We only have to worry if it turns out that more and more of the people who are appointed as arbitrators don't have that moray in the background, because that's not what they learned where they were. And, you know, the public international lawyers, let's say, who worked for the state originally, or did something private but that involved public international law, those folks might not know of this cultural taboo against dissent unless you really have to. But since I don't think we have that world, since I still think that the community is largely based on a commercial model, which was, of course, as Chuck said, the model they chose, I don't think that this is really a problem.
Can I just add, I think one of the most interesting comparisons isn't necessarily investment arbitration to commercial arbitration or arbitration to litigation, but awards versus annulment decisions, because you see many more dissents in awards or jurisdictional decisions than you do in the annulment context.
So we've come to the end of our time, but as any good panel in their deliberations on an issue, I'd like to ask for just a quick final response, and this can be your personal view or playing along with our game, but where are your final views if I've missed anything here? Todd, anything to add before we finish off?
Shockingly, no.
I'd say it's complicated and it depends.
Yep.
I agree.
Isha?
Yeah,
Okay.
definitely it depends.
A concurring separate opinion, Mallory.
Well, I think that then takes us to the end of this panel, and I wanted to take the opportunity to thank everyone, Isha, Chuck, Mallory, and Todd, for taking the time and putting your thoughts to this. And on behalf of the group here, I'd like to indicate our thanks, and we'll finish off here and look forward to seeing you at the next Washington Arbitration Week panel. Thanks very much.